Good evening. We will call to order the Senate and House Judiciary Committee Conference Committee. And we will be conferencing on Senate Bill 58 and Senate Bill 60. We are going to stand at ease until 7:30. So we are going to stand at ease or be in recess until 7:30 p.m. Thank you.
I'm sorry.
Evening, we will call the Senate and House Judiciary Committee Conference Committee back to order. And we have some business on the floor to attend to in the chambers. So we will be in recess again until 8:15 p.m. Thank you. Evening, everyone. The Senate and House Judiciary Committee's Conference Committee will come back to order. And I think we're going to start with looking at Senate Bill 60. Senate Bill 60, if everyone will recall, it's, just a minute, I'll pull it up for us. I'll give you the short title, and then the reviser can tell us briefly. It's defining proximate result for purposes of determining when a crime is committed partly within this state. Mr. Reviser, Mr. Thompson, I think, yes, we see you on WebEx. If you could give us a brief, well, we'll leave it at that. And I think then we have some other House bills that we were talking about, that we were thinking about putting that into Senate Bill 60. Senate Bill 60 was amended by the House Committee of the Whole, which is not the Senate position. The Senate's pretty firm, I think, on maintaining the Senate position on Senate Bill 60, but we'll discuss and we'll see what we've got as far as other bills we're going to think about putting into Senate Bill 60. So,
Very good. Thank you, Madam Chair. My hope on behalf of the House, and we can just kind of talk through this, and then maybe I can make an offer, but at this point, let's just kind of talk through it. I was hoping we could take the House position on Senate Bill 60, which includes a language dealing, adding to the crime of sodomy when a victim has given consent, but certainly did not give consent to the crime of sodomy. And so that, in a sense, that's what we added on the floor. I believe Natalie has a slight amendment to that, which would add a whereas clause calling that provision Val's law, but we can talk about that as we move forward. So that's Senate Bill 60. To that, we had a number of House bills dealing with crimes, so it would fit in Senate Bill 60 as a crime bundle. Two of them you passed out of Senate Judiciary. House Bill 2001, which is the sexual extortion bill, and then House Bill 2093, which is fleeing and eluding. So kind of starting with those, and if we were to add those, we would have two more potential bills that we could put in according to our rules, where we can have 4 + 1. And in my mind, there's kind of 3 to choose between. We have House Bill 2362, which is abuse of a child. I don't know that it's ever made it over to the Senate side, but House Judiciary for the last couple years has worked on that, and the County and District Attorneys Association has been trying to tweak that and get it right over a couple years, and it passed 124-0 out of our side. The next one would be the spousal exception to sexual battery or sexual assault. I should pull that up to make sure I get that right. Give me 1 second. It is battery. Yeah, spousal exception from the crime of sexual battery. That's another one that we've had, I think, 3 years in a row on the House side, House Bill 2120. And then the third one that could go in would be Senate Bill 204, which is the Greg fix. Obviously, that passed out of the House because it's a Senate bill, or it passed out of the Senate because it came from the Senate. We passed it out of the House, and it died below the line. So 2001, 2093 are two that passed out of, in a sense, both passed out of your committee at least. And then the 3 to choose from would be 2362, 2120, and 204.
Thank you for the recap. We did pass out 2001 and 2093 out of committee. Senate Judiciary did not have a hearing on 2362 or 2120. We did on Senate Bill 204. In fact, on 204, we passed that out of committee, and then it was stuck below the line and stricken from the calendar. So we're going to stand at ease for just a moment, if we could. Thank you. Was there an amendment to Senate Bill 60 you wanted to present, or? Oh, it's the whereas. It was adding the.
Yeah, the whereas, which would just name that provision that we added. It wouldn't end up in the statute books. And that, maybe Natalie, do you want to explain how you would handle that? It is correct.
Sure. Thank you, Mr. Chairman. Yeah, the way we would typically do that is just add a whereas clause above the enacting clause that just says the provisions of whatever section that ends up being in the bill, the amendments made to that statutory section are hereby known as VAL's law. And those
Thank
would
you.
be, and just for clarification, Chairman Patton did mention the sodomy section, but that there is a provision that also involves sexual battery in that provision as well.
Correct.
Thank you. Then we'll stand at ease for just a moment to consider what the plan was that you talked about. Thank you, committee. Did you have a written copy of the proposal you have for Senate Bill 60? And is it just the whereas clause, or it's something
It is
else?
just the whereas clause.
It's just the whereas clause.
And I've not seen it, but I bet Natalie has it. Is that correct, Natalie? Oh, she's shaking her head.
I haven't, Mr. Chairman, I haven't drafted a balloon on that or anything. If you want to see the specific language, I can work it up really quick, but it would just be, everything would be before the enacting clause. There would be no change in any of the statutory language.
And the whereas clause would then be printed in the statute book?
It,
No, it's just.
It would not. It would simply be in the conference committee report.
I understand. Just a moment.
Sure.
Thank you, committee. Is it the House's offer that Senate bill, tell me again exactly what the House offer is. You've kind of talked about a couple of bills, but do you have a specific offer?
Give me 1 second. Okay. Our offer would be Senate Bill 60 as it left the House, add in the whereas clause, and then add the contents from House Bill 2001, 2093, 2362, and 2120.
All right, now that we're clear, because we were talking about a couple of different ones.
Sure.
So just a
Okay.
minute. Thank you, committee. Thank you. We have a counter offer, and the counter offer is this. We keep the Senate position on Senate Bill 60 as it came out of the Senate. And in Senate Bill 60, we also include 2001, the contents of 2001, the contents of 2362, and you had mentioned earlier in our earlier discussion about what was possibly on the table, you had mentioned Senate Bill 204. And we would put the contents of 2001, 2362, and Senate Bill 204 into the Senate position on Senate Bill 60.
Give us a second. Thank you.
Of course.
Chair, we are ready when you're ready. Okay, in exchange for sticking with your version of Senate Bill 60, we would propose adding the contents of 2001, 2362, 2120, and then I didn't clarify this before, but we would take your version of 2093. We actually have two versions of 2093. You changed it from willfully to knowingly, and we'd be willing to accept your position in 2093.
Repeat that again.
Okay, so Senate Bill 60, as you requested it, 2001, 2093, your version, not ours, 2362, 2 and 2120.
$20.93 as it left committee because it has not been across
Yes,
the
as
Senate
it
floor.
left your committee.
Okay, thank you. Let me confer. All right, committee. With the House's latest offer, we will counter with, instead of inserting the contents of House Bill 2093 as it came out of Senate Judiciary Committee, we will take that out and insert the contents of Senate Bill 204 into Senate Bill 60 and leave the rest of your offer in place. So we're basically swapping out 2093 for 204.
Madam Chair, we appreciate the offer, but at this point, we're going to stand firm on our last offer. 2093 is something that passed out 124 to nothing out of our side. It passed out of your committee. It's something we've heard from law enforcement that's extremely important to them, and it's something that we think should remain in any criminal bundle. We've given a couple positions in your direction already and would appreciate you reconsidering our last offer.
Thank you, and we'll stand at ease for a moment. Thank you, committee. We understand the House position, and thank you for it. Senate Bill 204 passed out of the Senate on the consent calendar. It's a bill to help victims of crime, and it's something that the Senate felt strongly about, and so we would stick with our counteroffer and reject your latest offer.
Yeah, Madam Chair, I think we're at a standstill then, unless you'd be willing to go back to the original position on Senate Bill 60.
It does look like we're at a standstill then.
Okay.
But we do have another Senate bill to discuss. Senate Bill 58. And we've been hearing, so Senate Bill 58. I'm going to try to read the short title real quick of Senate Bill 58. Is concerning liens or claims against real or personal property relating to prohibitions on certain filings, notice criminal penalties, and it's a shell at this point because the contents of Senate Bill 58 have been put into another bill. So we have a shell to be working with. We have heard over the last couple of days that there are some questions about the intent and the application of Senate Bill 40 that passed the Senate. It was regarding KEMA, some Kansas Emergency Management Act updates and continuation of some procedures and some clarification on that we've been hearing it needs some further clarification of those who have been putting it into practice, if you will, the courts, the school boards, and needing to address that. So we have a proposal to clarify the intent and the application and the use of Senate Bill 40. So we have brought that to committee to share with committee and make it our Senate offer to put into the shell that we have, which is Senate Bill 58. So at this time, we'll pass that out. So while we're distributing that, if the reviser, Mr. Thompson, could just briefly give us a quick bullet point, if you will, about how the proposal the Senate offer helps to clarify the intent of Senate Bill 40 and put it into practice.
Thank you, Madam Chair. Jason Thompson with the reviser, trying to share proposal. All right, it's not going to show up for me. There we go. All right, so, and not to dwell too much on the policy kind of statement we were making there, but this would amend a few sections of Senate Bill 40 or statutes amended by Senate Bill 40 or created by Senate Bill 40. The first is Section 1 of Senate Bill 40, which was the schools provision. School boards have the authority over their school district. The changes here would be on page 2. You see this one would clarify that the hearings shall be conducted by a majority of the full membership of the board, not some other body or any other number, but a quorum of the board, essentially the majority of the membership. In this subsection about how you file your request and if you're aggrieved and you want to request a hearing before the school district, you would file a written request with the clerk of the Board of Education. And then there's a provision here that's not necessarily a clarification, but would be an addition that the board may disclose the name of the person who filed the request to the public, but all other identifying information would be confidential. So that one's maybe a new provision. Page 3 here, upon receipt of that written request, again, just clarifying a written, the Board of Education shall conduct their hearing within 72 hours of receipt of the request by the clerk of the Board of Education. Maybe clarifying a little bit the timing of that, when that clock starts ticking. And then the board shall issue a decision within 7 days after the hearing is commenced rather than conducted. So the beginning of the hearing rather than the ending potentially. And then there's some time computation for the lawyers in the room there. This is drawn from 60-206 in the Code of Civil Procedure. although it does not have the final provision of each of these timing provisions you'd find there, where you roll over to the next day, essentially. That would not apply here. So these are specifically in counting the hours, you count the day, you count it immediately upon occurrence of the triggering event, you count every hour, including intermediate Saturdays, Sundays, legal holidays, period. You don't go to the next day, even if the period ends on a Sunday. That would be the end of the period, would be Sunday. And that would be the time that the hearing has to occur under this clarification that's placed here. Same for the 7-day period. It doesn't include the day that triggers the period, but it counts every day after that, including Saturdays, Sundays, holidays, and it includes the last day of the period, even if that last day is a Saturday, Sunday, or legal holiday. So the opinion would have to be issued even if it was a non-business day. And then this next issue here is the Board of Education can adopt rules of procedure consistent with this section. Might just clarify that intent. Probably implied before, but would be explicit here. And then you move next into subsection D, which is the appeal to the court. You may recall from SB 40. This sentence added here would indicate that the pleading must comply with KSA 60-211. Again, this is a civil action, so that was already true, but just an affirmative statement that it has to comply with that. And further, that it need not be verified or accompanied by an affidavit or declaration, which is also what 60-211 says, but it would just place it here specifically. I guess there's been some question about that the chairperson may elaborate on, but this would explicitly state that those requirements are applicable here, and you can't be required to have a verified petition. It's just a pleading that complies with the statute. Then this small change here, the court shall conduct a hearing within 72 hours after receipt of a petition. It would be after a petition is filed. So as you know, in a civil action, you file your petition, and in that case, that would start this clock. A small change, but maybe an important one for timing. And then similarly, the court shall issue an order on the petition within 7 days after the hearing is conducted. That would become issue their order granting or denying the petition within 7 days after the hearing is commenced. Again, so from the start of the hearing, not the end of the hearing, and it's a little clearer that there would be a granting or a denying, not just some order continuing or some other kind of order. It would have to be an order addressing the merits. And then the changes here in the new language is that the court will not be able to require the petitioner to do certain things. I'll mention these are drawn specifically from one district court's administrative order. This would specifically say that those things cannot be required. And I'll let the chairperson elaborate on why these three were chosen and called out specifically. Paragraph 4 there would allow for a prevailing petitioner to receive attorney's fees. So that would be a new addition. Obviously, under our current law in Kansas, that would not be allowed unless you make it allowed by statute. So this would do that. That is not necessarily a clarification, but would be a new item to the bill. And paragraph 5, a knowing violation by the board, say of the 72-hour provision, for example, could lead to a civil penalty similar to a violation of the Open Meetings Act or the Open Records Act. You can have a civil penalty assessed to your body. If they violate those acts, this would be the same kind of mechanism. And if that was assessed, it would be remitted by the clerk to the state treasurer and go to the state general fund. And then paragraph 6, all of the current district court administrative orders related to procedures that are currently adopted prior to the effective date of this act will be null and void. So the one that I was just mentioning a little bit ago would be voided by this, and the district court would have to issue some new administrative orders. Item 7, clarifying that the Supreme Court can adopt rules consistent with this subsection. Again, probably implied, but clear. And then finally, subsection E, allowing any action, making clear that this section applies sort of retroactively. So if your action was taken prior to March 25th of 2021, the effective date is Senate Bill 40, but the aggrieved person was still aggrieved by that action because it was still in effect at that time, you are allowed to bring your request for hearing, have your district court action, et cetera. There was some discussion about whether it was retroactive to those provisions or not. The same section, same changes are made to section 2. For community colleges, the language is slightly changed to governing body instead of board, so I won't go through those. And then the changes down below, and I'll just use section 3 as the example. So we don't have to go through each of them, but they each replicate the court provisions because they don't have the appeal to the board. So I'll highlight those, and I want to highlight one other change that I nearly forgot that came in today. Section 3, which is amending 48-925. There's a small change on page 10, but a significant one potentially, where the LCC calls their meeting to occur within 24 hours of the issuance of an executive order. That just happened last week, as you may recall. This would give them 72 hours to have that hearing rather than 24. So one number change there on page 10, but significant for the LCC and for the order review. And then the other changes I mentioned regarding the court process are in subsection G of that section. All of the changes we talked about up there above would be applied here. So the pleading has to comply with 16-211. The clock starts ticking when the petition is filed. The order has to be one granting or denying. It's based on when the hearing commenced, not when it was conducted or ended. All the provisions about not requiring the petitioner to do certain things, may award attorney fees, and then there's no penalty provision here because there's no board to apply it to. So that's gone, but all the administrative orders would be null and void. So sections 1 and 2 kind of have two sets of provisions, and then the rest of the sections have these just court provisions. Hopefully that walks you through it, and I'll stop there and see if you have any questions.
It does, thank you. So you can see that what we have here is it really does clarify some things that were not particularly clear with the language that we had before. So you have to file the petition with the court instead of just receiving it by the court, which wasn't, when you start a petition in court, it's filed. So changing that language to make sure that the intent of the court, or excuse me, the intent of the legislature is set forth, and how you compute the 72-hour period. We are hearing from those that are requesting these hearings that it's the 72 hours isn't, it's having some challenge to it, if we can say it that way. And also that we wanted to be clear that the elected officials must meet to conduct the hearing that has been requested. The whole point of Senate Bill 40 was to always, in every instance, make an elected official ultimately accountable. And that would mean the hearing conducted by that elected governing body. And we are hearing that in practice, some of the governing bodies are retaining third parties such as legal counsel to conduct the hearings. And that is not the intent of Senate Bill 40. It was the intent of both the House and the Senate and the governor when it was signed into law that the requested hearing by the aggrieved be held by the members of the governing body. We also wanted to clarify the intent regarding what the petition would require, and we have set that forth. Do you all need a few minutes of recess or standing at ease to take a look and discuss? Or did you have questions for the reviser first?
Personally, I know I'm going to need some time to digest this. I mean, I don't want to agree to making changes and then have to, well, I guess we won't be back next week, but don't want to make mistakes and have to fix them again. So I want to make sure if we're going to change anything, we get it right. It appears as though Representative Ralph grabbed his microphone. Do you have some questions?
Yes, thank you, Mr. Chair. I would agree with you. The extent of changes here that are being proposed, as I looked back with just 14 days since we've considered this and put this into place, and we now have what appears to be some pretty significant changes or additions to procedures and processes. But a couple of items jumped out, and since we've got everybody right here, if I might ask a couple of questions in regard to the content here, but I'm sure we're going to need more time than just this evening. But if I might pose a couple of questions that jump off just from the description from the reviser at this time.
Sure, go ahead.
One of them that caught my ear was the description that, and It's found at page 3 under subsection D as in dog 1, and it looks to be an addition saying that such pleading, and this is referencing to an aggrieved party, whether it be an employee or a student or a parent constituent, talks about that they now have to, if they file that civil action, both at the board or in the district court, that talks about filing a pleading that complies with 6211. And in looking back at 6211 provides what's contained in a petition, but also provides provisions for sanctions if you, in essence, have problems or concerns with what you put in there. Is it truly the Senate's position that an aggrieved party, if they are proceeding pro se, and now you've placed them under a concern that they have to comply with the provision of 6211 and potentially subject themselves to sanctions from the court if they were not in compliance as that statute discusses?
Thank you for the question. I'll let the reviser answer first. It would not probably be the Senate position to put an aggrieved party who is proceeding pro se in that position. It was meant to clarify, and I just want to back up for a second here. We're not changing any procedures in Senate Bill 40. We're simply clarifying what the procedures in Senate Bill 40 are. So, but with that, if Mr. Reviser wants to answer the question.
Thank you, Madam Chair. Jason Thompson with the Revisor's Office. And thankfully, I have few practicing attorneys in the room that actually know the Code of Civil Procedure in practice better than me, since I just sit here and work for you all. But 60-211, I use here because it's just requires a signature. When you file your pleadings, it just specifically says every pleading must be signed. And it also specifically says it need not be verified or accompanied by an affidavit. And we had at least one court that said you must file a verified petition. So the attempt was to say, no, that's not what we meant. 60-211 applies, you just sign it. And then reading through it, it would apply because this is a civil action, even if I didn't say it applied, because you're representing to the court by your filing that to the best of your knowledge, certain things are true. You're given a chance to respond if they think you violated that subsection, and then they can impose sanctions if they think you're not carrying through. So my understanding is that this already applies even to pro se litigants. And if I'm wrong about that, we can limit it to, the provisions of 60-211A relating to the signature, could apply. But as far as I understand, this is a civil action and the whole Code of Civil Procedure applies. And I'm not trying to add anything to it. If I made a mistake there, please call that to my attention.
No, I would not in any fashion think that there's a mistake there. I just wanted to make sure, because under 6211, yes, in fact, a person who files in compliance with 6211 is potentially subject to sanctions. And it was my understanding in this that part of what we were doing in terms of intent with the original bill was to create ease of access and simplicity of access, not only at the level of the Board of Education for this specific section, but into the courts, make it easy and quick to get there. And the more we start referring to specific statutory requirements for the content that's done, we're going to be forcing people to retain counsel when, as I understood, that's not anything that we intended to do in terms of forcing them to do that. And the more we refer to statutes and the more we put requirements on there, as opposed to allowing someone simply to, even as you do with a small claims action or whatever, if I write down, this is my complaint, and I get it over there to the court, I'm pretty certain at this point, I haven't heard anybody talk about there being a concern that a court has turned someone away, a pro se litigant or a pro se aggrieved party, turned them away because of the form of the content of what they have submitted. If we start down this road, we are simply going to create traps and problems for folks that are attempting to get into the courts and get their situation addressed quickly and conveniently to them. So that's just one of the things that jumps out there. Another question that I've got, looks like we're starting to count hours on our 72 hours. So it would appear here then that under this 72 hours, we could have a Board of Education starting a hearing at 10 o'clock in the evening, because they got served at some particular time, and they've got to get that in before 8 o'clock the next morning, and so we're starting hearings in the middle of the night to comply with counting by hours. Is that the intention here? And I'm
Thank
looking
you,
at page 3.
Representative. You raise very good points. Before we leave 60-211, very good points. It's not meant to be burdensome. In fact, that's the whole reason that Senate Bill 40 was put into place. So I haven't heard an offer yet, but at least as far as subsection D on page 3, I mean, we could start that sentence quite frankly at, such pleading need not be verified, and just strike the 60-211 part, because you're right, we want to make this ease of access for those aggrieved parties and not have to retain an attorney, and even probably strike the pursuant to KSA 53-601 in that same sentence. So to your point exactly. And I know that's kind of not an offer we're discussing, but I like what you're thinking and where you're going with that.
Yes, Madam Chair and Mr. Chair, certainly not my position or my place to be making offers or suggestions. And as we talked about when we were last in committee discussing Senate Bill 40, raising questions here, it's not my intention to try to fix. I think we are good where we're at on the original bill that has been passed. So I don't intend by my comments to indicate that it would be my intention to think that we go through and fix this right now. I think our position is good as it is. I did have one other item that I wanted to point out, and then I'm going to relinquish the microphone back to the chair here at this point.
Well, I think I'm the chair of the committee, but I want to answer your second point before you raise your third, if we could, because then we're going to get too far down the line. We're going to lose track of where we are. To your point, well, you've asked, well, have people had trouble getting to court, and we don't want to make it more burdensome and that they've got to go through these formalities. In fact, the part of the reason that we need this Senate position and that we need to clarify the intent of Senate Bill 40 is because we do have an instance where a district court has issued in an administrative order interim procedures for civil actions under Senate Bill 40. And if you've looked at the copy of it, they are onerous, burdensome, difficult, and in fact, they place a high bar, a lot of hurdles for an aggrieved party to get into court. And that's partly what these clarifications of Senate Bill 40 are intended to do. I have a copy of the administrative order that I'd be happy to pass around to have you take a look at, because I think once you see them, you'll find that it's pretty onerous, which is what was brought to the attention of the Senate and why we have this Senate position, because we've been hearing from aggrieved parties about some of the enforcement of Senate Bill 40. So we're going to have to recess because we're on final action on the Senate floor, and then we will hear the representative's third point that he wanted to raise. Thank you. So we'll stand in recess until 9:45. everyone for allowing us to stand at recess. We are called back to order. And we were about to take up another question from Representative Ralph, but I wanted to not leave his second question about, why do we need this? And I don't have a copy of what I was going to read. A little bit. We have an administrative order from one of our district courts that.
Madam Chair,
Yes.
we're on final action.
You're on final action. All right. We
to
will
see
be
you.
in recess then.
Be right back.
Till 10:30. Okay, till you push your button. Thank you, gentlemen. Committee, we're back in order. I was getting to the reason that we need the clarification for Senate Bill 40, and to the representative's second question, if we could pass out, we have an example of a district court administrative order putting into place interim procedures for civil actions under Senate Bill 40. And as we pass these out, it's just an example of one court, but I think it would be a bellwether for how other courts might put into place procedures and how Senate bill might be misapplied or misinterpreted. And I want to draw the committee's attention to paragraph 3 in particular. The last sentence, you'll see that the administrative order provides some burdens and in fact switches the burden of proof from its place in Senate Bill 40 on the government and puts it on the private citizen, the aggrieved party, the aggrieved business. The last sentence of paragraph 3 states that the petition from the aggrieved person, who we're trying to make it as easy to get into court as possible, the allegations must show with specificity and not by mere conclusory language how the petitioner's burden is substantially different from the burden upon persons or entities similarly situated who are not included on the petition. That's certainly not the intent of Senate Bill 40, and that places a burden on the petitioner that is not the intent of the legislature in Senate Bill 40. If we turn to paragraph 6, this is where I find that the burden of proof is shifted as we have it in Senate Bill 40 from on the government, and this switches it to on the petitioner. Such petitions must specify how the order, which is the subject of the action, could be more narrowly tailored to respond to the disaster emergency addressed by the order under review and suggest less restrictive means, if any, to achieve such purposes. That's the government's burden of proof in Senate Bill 40, not the petitioner in this administrative order. And finally, paragraph 7, the petitioner must certify whether they had an opportunity to appear and be heard prior to the adoption or issuance of the order under review, and if so, whether they did appear and express their aggrieved burden and whether they suggested the alternatives expressed in the petition. I find that these are not the intent of Senate Bill 40, and I think upon review, others would most likely agree. So that is what has brought to the attention of some in the legislature that we need to clarify the intent of Senate Bill 40. And we are hearing from some school boards have heard hearings already, and we are hearing that rather than the hearings being presided over by the elected officials, they are having third party conduct the hearings. And again, it was the intent of the legislature that we get the aggrieved parties in front of the elected officials to provide accountability. So just wanted to put that out there, that that's some of the reasons why the amendment to Senate Bill 40 is necessary. I think this is good information for the House committee and the House to talk over and discuss, along with the amendment there. And so with that, we can probably recess until tomorrow morning. If you guys have any concluding remarks that you would like to make, and I mean concluding for tonight.
I think that works for us. We, as I suggested earlier, need a little time to dig through this, and I want to make sure if we decide to do anything that we get it right. And so we would appreciate some time to continue looking it over it. And we're going to be bouncing back and forth all night, I think, each chamber to the floor, and so we're not going to be very productive this evening anyway. So in the morning, hopefully we do have a chunk of time that we can talk about not only what we want to do with Senate Bill 58, but potentially maybe getting back to Senate Bill 60. You guys decide to budge a little.
Right, you guys decide to budge a little. So, well, let's go ahead and we will then recess until 8:30 a.m. We will need a room which Legislative Administrative Services will get in place for us, and then we will now recess until 8:30 a.m. April 9th. Thank you.